On 15th July 2025, MinLaw announced that inquiries into 11 out of 24 law practices involved in conveyancing transactions for seized properties have concluded. The Director of Legal Services ordered 2 law practices to pay financial penalties of 30,000 Singapore dollars and 100,000 Singapore dollars respectively. A third law practice has received a statutory notice of the intention to impose a penalty of 70,000 Singapore dollars, pending written representations. Another law practice has received a private reprimand, while one lawyer has been referred to the Law Society for possible disciplinary proceedings. MinLaw's statement confirmed that no further regulatory action will be taken against 7 of the 11 concluded cases. Inquiries into the remaining 13 law practices are still underway to determine if further penalties or referrals to the Law Society are warranted. The press release did not identify the names of the law firms involved in the regulatory breaches. The 2023 money laundering case saw illicit profits from an illegal gambling syndicate laundered through high-value purchases, including luxury vehicles, designer watches, jewelry, cryptocurrency, and real estate in some of Singapore's most affluent districts. Authorities seized more than 150 properties as part of the extensive investigations. According to MinLaw, the illicit gambling operations targeted punters in China and operated across Southeast Asia, generating millions that were channeled into assets in Singapore. Under Singapore law, all lawyers and law practices are required to comply with robust anti-money laundering rules. These obligations include conducting thorough risk assessments for each client, implementing customer due diligence in accordance with the client's risk profile, and filing suspicious transaction reports with the police when necessary. If there are reasonable grounds to suspect that a client may be involved in money laundering, lawyers must justify any decision to continue acting for that client and put in place enhanced due diligence and monitoring measures. Failure to meet these obligations can lead to regulatory action against a law practice's license. Individual lawyers who fail to comply may face disciplinary proceedings that could result in fines, suspension from practice, or permanent disbarment. MinLaw reiterated that law practices must maintain internal policies, procedures, and controls that meet statutory anti-money laundering requirements and are sufficiently robust to detect suspicious activities. In response to the evolving risks, the Ministry of Law issued a new guidance note to the legal industry on 23 June 2025. The guidance outlines best practices for client risk analysis, identification of red flags, verification of a client's source of wealth, and the monitoring of clients and transactions over time. It also sets clear timelines for filing suspicious transaction reports. MinLaw emphasized that Singapore's anti-money laundering regime is comprehensive but must adapt to new threats and typologies. A spokesperson said, "Everyone has a role in ensuring that Singapore's anti-money laundering systems continue to be robust, from the law enforcement agencies to service providers, such as the financial institutions and law practices, to the general public." The Ministry's continued inquiries and recent enforcement actions signal a strong stance on ensuring that the legal sector upholds its role in safeguarding Singapore's reputation as a trusted financial hub. Earlier, on 4th July, the Monetary Authority of Singapore announced that 9 financial institutions had been fined a total of 27.45 million Singapore dollars in composition penalties for breaches linked to the 3 billion Singapore dollars money laundering scandal. Regulatory action was also taken against 18 individuals who managed relationships with suspects in the case. The breaches included failures in client risk assessments, verification of sources of wealth, transaction monitoring, and the timely follow-up of suspicious transaction reports. MAS stated that it would maintain close oversight of the remediation measures implemented.